And welcome to our third and final day of this training course. I would like to welcome everybody present here, and especially our speaker, Dr. Mehrdad Khanlar-Kalkhani. I would like to welcome you all. Just let me give a few introductions first. Okay. Dr. Khanlar-Kalkhani, can you hear me? Can you turn on your video, please?
Yes, I can hear you clearly. Let me turn on my video. All right. Good morning. Can you see me?
Bright and clear.
Perfect.
Okay, so a few words of introduction to our participants. Dr. Mehrdad Khanlar-Kalkhani has a PhD in chemical engineering from Tariq Madaris University and director of the patent drafting department of Idesazan Asr Aftab company, with more than 10 years of experience in the field of examination, drafting of inventions, and a lecturer at the Patent Center of Iran. Welcome to our sessions, to our online session, and I would like to give you the mic now. Thank you.
Thank you. Thank you for your kind introduction. Okay, if everyone can hear me loud and clear, let me share my screen and get on with my presentation. Okay. All right. Okay, I take it you can see my screen right now.
It's on.
It's on. Good. Let me just rearrange everything here. Okay, the video goes here. Great. All right. Okay, hello everyone, and welcome to the third day of this online course. As I was kindly introduced, my name is Mehrdad Khanlar-Kalkhani, and the topic that I'm going to talk about today is on patent application process. What we will be is focused on the international patent system and regional patent systems. I don't want to dig deep into boring detail of patenting stuff, because as you know, it's very complex and at times very boring. I want to keep it an interactive presentation, so feel free to ask your questions during the presentation, and sometimes in the middle of the presentation I will ask you questions, and I would really appreciate it if you could answer those questions, yes/no questions, in the chat section. Of course, at the end of the presentation, we will have 30 minutes or more for your questions, and I will be at your disposal, and I will try to answer all of your questions. And I hope it will be an efficient and presentation. All right, let's get on with it. All right, before we start talking about international patent systems and regional patent systems and patent system, I'm sure that my esteemed colleagues have talked about patent system with you, but let's review it one more time. Let's look at the patent system and what it actually is. The patent system can be considered as a kind of social contract and the public. Why does a patent applicant want to get a patent? Because they want exclusive rights. They want to protect their invention. What does it mean to protect their invention? They want to be able to sue people legally if someone tries to copy their invention, if someone tries to make, use, or sell their invention without their permission, because they want to make money off of that technology. So they try to get a patent on their technologies, to have exclusive rights, to receive exclusive rights from the public. But in return, they have to give something back to public. And what is that thing? That is sufficient disclosure. If someone wants to get a patent on a technology, they kind of have to describe their technology. The public says, all right, we will give you the exclusive rights to protect your invention, but in return, you have to describe how your invention is made, what is the structure of your invention, and how your invention is used in a sufficient manner. It means that if we want to get a patent on our invention, we have to prepare a specification, which is a written text describing in detail what our invention and how it is used. Drawings of our invention to go deep into the detail of the structure of our invention and disclose it fully to the public. So this is how the patent system works. So if someone wants to keep their invention secret, or they want to keep a portion of their invention secret, the patent system is not for them. They can, protect their invention by cheaper methods like trade secrets. They can sign non-disclosure agreements with their employees who have access to the information regarding their invention. They can, secure their databases where they keep the information and technical information about their invention, and they can try and they can do their best to protect it. But if they want to get a patent on it, it's exactly the opposite. They have to describe it. They have to disclose it, because the public wants access to the state-of-the-art technology, because public wants to build upon it, wants to, move the technology forward. So they need to access the information about your invention in return to the exclusive rights that they give you. Okay, let's just see what these exclusive rights are. All right, let me just move this here. All right. Okay, a patent holder, someone who gets a patent on his technology, has the right to prevent others from making, using, or selling the claimed invention in the country where the patent was granted for a limited period. In addition to that, a patent holder has the right to assign, sell, or license these rights. All right, let's just look at it closely to see what it means. What are these exclusive rights and what limitations we're facing? Let's read the sentence one more time. A patent holder has the right to prevent others from making, using, and selling. So a patent right is a negative right, not a positive one. It means that the patent does not give you the right to make, use, or sell your invention, but it allows you to prevent others from making, using, or selling. Why can't you make, use, or sell your patented invention? Because a portion of it might be the subject of other people's patents. So in order to make your invention, you may need the permission of other people. For example, imagine you have invented a computer mouse. A computer mouse has so many different systems and subsystems. Invented the scroll wheel on a computer mouse. That's your contribution to that technology. But the basic structure of a mouse might be the subject of someone else's patent. If you want to produce a mouse scroll wheel, you need to get the permission of those people who are holding the patent on the basic structure of the mouse. So a patent does not give you the right to make, use, or sell your invention, but it gives you the right to prevent others from making, using, or selling your invention. This is the first important point in this sentence. Just let's read it again. Let's read it again. A patent holder has the right to prevent others from making, using, selling the claimed invention the claimed invention. This is something that I will discuss further in later stages of this presentation. But just see, what does it mean, the invention? We have prepared a specification, we have described our invention, and we have shown our invention in our drawings. What does it mean, the claimed invention? You see, one of the most important parts of a patent application is the claim set. The end section where it begins with I claim, we claim, and you see a set of numbered claims at the end of any fine line. That section is the most important part of a patent application. Claims determine the scope of protection of our patent application. So do we have exclusive rights on whatever we've described in the specification and whatever we've shown in the patent drawings? No, we only have exclusive rights on the things that we have claimed in our claims. That's why in this definition, it says we have the right to prevent others from making, using, selling the claimed invention. I will discuss it further. Okay, let's continue on reading the sentence. A patent holder has the right to prevent others from making, using, selling the claimed invention in the country where the patent was granted for a limited period. So if you get a patent, let's say in Pakistan or in Iran, that patent, that Iranian patent, that Pakistani patent is only valid in the country that you have obtained it. An Iranian patent is only valid in Iran. A Pakistani patent is only valid in Iran. So it is valid in the invention for a limited period. Is the patent valid forever? No, for a limited period. Let's dig deeper into these limitations. The first thing that I discussed about the country you obtained a patent in is called the Territoriality Principle. A patent granted in one country has no effect beyond the territorial boundary of the country, cannot be infringed upon in other countries. That's an important thing to consider when you're looking at a patent system. So if I get an Iranian patent on my invention, I can only have and I can only benefit from the exclusive rights in the boundaries of Iran. Okay, so imagine I have invented a medical device and I have gotten a patent on it in Iran. Can someone infringe upon my patent in, let's say, Pakistan? Can someone make, use, or sell my invention in Pakistan without my permission? Can they? I take it everyone can send messages in the chat section. Yes. Right? So the answer is yes, they can freely make, use, or sell that invention. Why? Because an Iranian patent only gives me an exclusive right in Iran. So if I get a patent on my invention in Iran, anyone in Turkey can make, use, and sell my invention, and I cannot do anything to them. Anyone in any other country can, benefit from my invention. So what should I do? What should I do to get protection in more than one country? I should apply for patents in every country that I want to benefit from the exclusive right, one by one. If I want to benefit from exclusive rights in Turkey, I have to file a patent application in Turkey and get a patent on my invention in Turkey. If I want to protect my invention in Pakistan as well, I have to file a patent application with Pakistani Patent Office and get it prosecuted and get it patented. Okay, so this is called the Territoriality Principle. When we are talking about the PCT system, and we will come back to this Territoriality Principle. So keep it in mind. Okay, someone is written in the chat section that many inventors create patents in the USA or European Union as it is easier to challenge and fight a legal battle for anybody who infringes in any other territory. No, it is not right. Anyone who gets a patent in the USA or European Union only can start a legal battle in the territory of the US and European Union. If someone gets a patent on an invention in the US and the European Union, anyone in any other territory can make, use, or sell their inventions without any legal limitations. Okay, and they cannot start a legal battle against them. All right, so this is called the principle of territoriality. All right, another limitation is patent term. We know that the maximum time during which a patent may be maintained in force is limited. In most countries, it is 20 years from the filing date. So if I file my patent application in 2021, my patent is valid up to 2041, 20 years after the filing date. That's another limitation. But we know that most patents are only maintained for 4 or 5 years out of these 20 years. No one, it is a reason that someone maintains their patent for the entire 20 years, because you know, and I'm sure it was discussed in the previous 2 days, that in order to maintain your patent valid during these 20 years, you have to pay some annual fees to the patent office. And if you stop paying those fees, your patents will be considered abandoned. And those maintenance fees increase incrementally as we get closer to the 20 years. It is costlier every year to maintain your patent. But because the technology is moving really fast, it is practically not feasible to maintain your patent for 20 years, because you can exploit your invention for up to 4 or 5 years. So most inventors, most applicants just maintain their patents for 5 years. They pay the maintenance fee for 5 years, and then they stop paying the maintenance fee, and their patent is automatically abandoned. Okay, someone is written here that if anyone patented something, let's say in USA, is it possible that someone else can copy and patent it in another country? Perfect. Perfect question. What I was talking was about using the invention. I said if someone get a patent for an invention in the US, anyone in, let's say, Iran or Pakistan can legally copy their invention without any problem. But can they patent it? Can they look at a US patent and try to patent it in Iran or Pakistan? No. Why is that? Because that invention has been disclosed. That invention has been published, and it lacks the novelty if you want to try to patent it again. So you cannot patent something that is patented in the world, because it is disclosed and it does not have novelty. And if you do so, the examiner of the patent office says, look, pal, this invention has been filed in the US, this is the disclosure, so your invention does not have novelty regarding this patent application, so you cannot get a patent application on it, but you are welcome to benefit from the invention. You are welcome to use it, sell it, or make it here, because the inventor has not obtained a patent here. I hope I could make it clear to you. So we cannot get a patent on it, but we can use it. Okay, so but then how one person can patent in more than one country, as it has been publicized already somewhere else? Exactly, this is something that I will discuss later in this application. What are the mechanisms that allow an inventor to get a patent in several countries? This is basically what I'm here to discuss today. So we will get to the answer to your question, sir. Or ma'am, I don't know. All right. So this is another limitation, the time limit. It's 20 years from the filing date. Okay, let's move on to a limitation that is rarely discussed in these kinds of seminars. Patent applications have an important limitation in protecting your invention, and that limitation lies within the claim. We call it claim limitations. I told you that the scope of protection of your patent is determined by your claim set. Look at this example that I have here. On the left side, you see an independent claim. It says what? Claim 1. a targeted anti-cancer drug comprising a polymeric shell, an anti-cancer agent encapsulated within the polymeric shell, and a magnetic agent encapsulated within the polymeric shell. Okay, how many elements does this invention have? This drug. This is a drug that we use to fight cancer, but because anti-cancer drugs can harm healthy cells as well, we want these drugs to go to a specific position in a patient's body and be released there. So that's why we create these targeted drugs that are able to go to a specific part of the body and be released. Okay, so how many elements does it have? It has a polymeric shell. It has an anti-cancer agent encapsulated, exactly as Mr. Kamran says, so 3. And a magnetic agent. So it has 3 elements: a polymeric shell, an anti-cancer agent, a magnetic agent. Okay, you get a patent on this claim. Someone in the country where you got this patent creates a targeted drug like the one you see in this picture. You see my pointer, right? You see my mouse pointer on the presentation. Anyone? If you can see my pointer, yes, thank you. All right, so creates a drug like this. Look at it. It has a polymeric shell, this yellow circle. It has a therapeutic agent with polymeric, and it has magnetic agents here as well, right? Okay, the question is this product infringing upon my claimed invention? Can I sue this person? It has all the 3 elements. It has a polymeric shell, it has a therapeutic agent, and it has a magnetic. Has he copied my invention? Kamran says yes. Omar says yes, he has copied. All right. Anyone else cares to venture a guess? Does it infringe it? The answer is no. This is not infringing my invention. Why? Because the scope of protection of my invention is determined by this claim. Look at this claim closely. What does it actually say? It says a targeted anti-cancer drug comprising a polymeric shell like this one, an anti-cancer agent encapsulated within the polymeric shell. Okay, this is an anti-cancer agent encapsulated. It means it is placed within the polymeric shell. But the last line reads a magnetic agent encapsulated within the polymeric shell. It means these triangles should be inside, not on the outer surface. So if I want to visualize what I have claimed in this claim, it's something like this. I have claimed this, but the product is this. So these are different products. It is not an infringing product. So keep in mind that the scope of protection of your patent is determined based on your claims. You might have described something like this in your specification. You might have shown something like this in your drawings, but you have only claimed this. Whatever you describe in your specification and drawings and not include in your claim set belongs to public domain. People based on the things you have said in your claims, not in your specification, not in your drawings. All right? This is the most important limitation. So it is clear that we have good patents and bad patents. What determines the quality of a patent? The claims. If the claims are crafted poorly, if the claims are written poorly, they cannot efficiently and effectively protect our invention. So we might get a patent on our invention, we might describe our invention sufficiently, but if we write poor claims in our patent application might not be able to prevent others from making, selling, or using our invention because it is not perfectly claimed. So what you must take from this discussion is that the exclusive rights granted in a patent are only valid for a limited period of time, only up to 20 years, provided that we pay the annual or maintenance fees. And if we get a patent in a country, our patent is only valid in the boundaries of that country. We should keep that in mind. And what we write in our claim set determines who we can sue. And a judge, a court, will based on supported by our specification and drawings. So patents are very complex. You might get a patent on your invention that is not able to protect your invention effectively. We will discuss this further down the road. Sirwan, no, being precise is not the case. Our claim must be designed professionally. We have to conduct a novelty search and see what the prior art is and how far we can broaden our claim and how many details we can include in our one single claim. So designing a claim is a very complex task. We should look at prior art to see what they're saying, to determine what we should include in our claim set and what we shouldn't include in our claim set. And we should have experience about prosecuting a patent application. We should know how a patent examiner treats the claim set and revise it so that an examiner cannot find problems in our claim set. We should have experience about patent courts to see how a judge will treat these claims later. So designing a claim set is very complex and should only be done by a professional who is experienced in both the technical field and the legal field. So we will discuss this further. All right, so let's just, yes, of course, Sirvan, you should utilize the services of a professional. Just like you don't write the deed to your house yourself, you utilize a professional's service to prepare the deed to your house. A patent is like a deed to your technology. Sometimes we are talking about $1 million technology, a $10 million technology. Are we going to risk of getting a poor protection and an expensive claim set ourselves? So, all right, you're very welcome, Sue. All right, let's just look at the process that we need to, take on to get a national patent application. If you want to get a patent application in a country, where should you go? You should go to the patent office of that country. For example, if I want to get an Iranian patent on my invention, I have to go to Iranian patent office. If I want to get an Indian patent, I need to go to the Indian patent office. So we are discussing the process of obtaining a patent in a sovereign nation, a country. An applicant who's here, who wants to get a patent on their invention, needs to hire a professional who we call a patent agent or a patent attorney. A patent agent and a patent attorney is someone who is familiar with technical fields and who is trained to be a lawyer. So he has both the technical and legal knowledge required to prepare a patent application. So the best practice is that if you want to get a patent on your invention as an applicant, you have to hire a professional agent or a professional patent attorney. And what you need to do is to hold a disclosure meeting with that agent or patent attorney and disclose or describe the technical aspects of your invention to that agent or attorney. You have invented something and you are an expert in that technical field, so you can perfectly describe your invention in technical terms. You can describe and disclose that technical invention to that agent and attorney. That agent, and they will use their legal knowledge and their legal experience to prepare your patent application. What does a patent? I was kind of forgetting that. In every country, you as the applicant have the right to directly file your patent application yourself. There is no mandatory thing going on for you to hire an agent or attorney. So hiring an agent or attorney is not mandatory at all, and you can yourself prepare your patent application legally and file it with the patent office. For example, I am an Iranian living in Iran. They want to get a patent on it in the US. I myself can log in to the online service of the USPTO and upload my information and upload my patent application and pay my fees with a credit card and, you know, try to get a patent application in the US. So why do I say that an applicant needs to hire an agent and attorney? Of course, it is clear based on what I said about the claims in the previous slide, because a patent application is a very complex legal document. So you do not risk losing your technology by preparing a poor patent application yourself. Get the help of an expert to prepare a high quality patent application. So what is a patent application made of? A patent application is made of a specification where you describe your invention verbally in a sufficient manner. It has drawings which show your invention, and you utilize drawings in your specification to describe your patent, your invention better. And it has the claims, which are the most important part of the patent application. So a patent agent and attorney will craft a claim information that you, and they will design and write the specification drawings such that they can support what is claimed in the claims. And then they file your patent application with the patent office. Most patent offices around the world have online services right now. There are online portals that you can log in and upload your documents and pay your fees online. So you don't need to go there in person. You can log in into their systems and upload your documents translated in their formal language of their country and file a patent application with them. It's not that difficult. So your patent agent or attorney prepares this patent application for you and double checks with you. And if you give them the green light, they will file that patent application with the patent office and, you know, prosecute it until they get a patent on your invention. But what does the patent office do with that patent application? Patent offices around the world have patent examiners. What does a patent examiner do? A patent examiner is an expert in a technical field who examines your patent application to see if it has all the patentability criteria. And what are the patentability requirements? There are three important substantial patentability requirements. What are they? novelty, which means your invention must be new. Inventive step, which means your invention should not be obvious to a person with skill in the art. And your invention should have industrial application, which basically means your invention can be theoretically be made and useful. A patent examiner examines your patent application to see if your claims have these patentability criteria. So the examination process in a patent office is focused on your claims. They examine your claims one by one and see if they have novelty, inventiveness, or industrial applicability. And then the examiner presents the results, the search results and the examination results in a formal communication that we call an office action. So he includes all his search strategy and the closest prior art that he has found to your invention, and he gives you his own opinion about the patentability of your claims in legal language, and then sends it back to you. So he performs a search on your invention to see if your claims are novel, inventive, or useful, and then he sends you back the search results along with his opinion about your claims. Then you have time, you have a certain amount of time to prepare a response to that result. You can argue that the examiner is wrong and my claims have novelty because of this, that. You can present arguments. You can amend or your claims, or you can revise your claims. You can change your claims in response to the action you receive from the examiner. And this back and forth correspondence goes on until the examiner says, okay, this set of claim is patentable. I've read your arguments, I've seen your amendments, and it seems that in the face of prior art, this claimed invention is novel, inventive, and industrially applicable, so I will grant you a patent. So this is another thing that makes using a patent agent more important. Why do we need to hire a patent agent? Because the patent office talks back to us in legal language. But we are inventors, we are innovators, we are university professors. We only understand technical language. We do not understand the legal language. So the communication between us and the patent office will not be effective. But if we hire an agent or if we hire an attorney, they understand legal language and they can communicate more effectively and get better results. It's another reason why we need to use patent agents. Okay, so the best practice is to have this communication between the patent office and the agent. Okay, I will give you an example to see what I mean by legal language. Let me move this chat box somewhere that is not. All right, look at this example. Do you see this frying pan? This is a cookware. This is something we can use to make an omelet on fire. This is a cookware. So let's see what this cookware is and how this cookware is claimed. We claim one, an induction cookware, this vessel, which is used for cooking. It's called an induction cookware, comprising a first compartment. You see this divider wall? This is a wall in the middle of this cookware that divides this cookware into two compartments, a first compartment and a second compartment. So let's see what the claim says. A first compartment comprising means including, comprising a first number of ferrous elements within a slots on a wall of the first compartment. So a first number of ferrous elements. Do you see these shaded areas? These are ferrous elements that are placed in a slot on the wall of the first compartment. And this vessel has a second compartment that comprises a second number of ferrous elements placed in a slot on the wall of the second compartment. This is what we have claimed. So an induction cookware that has two compartments, and in each compartment we have ferrous elements made of iron, placed in a slot on the wall of these compartments. This is what we have claimed, and this is what we made. This is the product that we are trying to protect by this claim. We file it with the patent office, and the examiner tries to determine if this claim is patentable. What do? They search the prior art and find something like this. In the right, you see what the examiner has found in prior art, and on the left, you see our claimed invention. Look at this. This is a cookware. This is something that is used for cooking food. This is a boxy thing with two compartments, one compartment, two compartments placed side by side. And each compartment is made of a ferrous material. The walls of each compartment is covered with a ferrous material. All right, so it's a cookware. It has two compartments, and each compartment is covered by a ferrous material similar to what we have placed here in its slots. Okay, my question to you is that, can this prior art cause the rejection of this claim because it's not novel? Can this prior art call the novelty of this invention into question? Can the examiner say that your claim is not novel, it's not new? It is disclosed in this art. Look at it. It's exactly similar to your claim. Can an examiner say that? Is it the same thing? Does it look like the thing that we have invented? It does not look. We are technical people. We are scientists. We are engineers. When we look at these two inventions, we see no resemblance. But legally speaking, these two things are the same as it is claimed. You see that the examiner does not have any concerns about how your invention is used and what are the benefit of your invention. When an examiner is trying to examine your invention, he looks at your claim and examines the claim. And as Omar shrewdly observed, they don't look alike. But legally speaking, in this claim, we have described this as well. Look, I have said an induction cookware comprising a first compartment. It has a first compartment, including a first number of ferrous elements within a slot on a wall of the first compartment. I said a first number of ferrous elements. One counts as a number, right? It includes one ferrous element placed in a slot on the wall. And the entire interior of this compartment can be considered as a slot. So this is a first compartment comprising a first number of ferrous elements within a slot on the wall of the first compartment. And this one is as well as a second compartment comprising second number of ferrous elements within a slot on the wall. So your claim is not novel. It is exactly this. So for a technical person, okay, if we receive an office action like this, we say, are you crazy? These things do not look the same. How can you say that my invention looks like this? It does not look anything at all like this. It says that I am discussing this legally with you, and I am examining your claim. In your claim, you said my invention has a first compartment. This invention has a first compartment. This art has a first compartment. You said it should have a ferrous element on the wall. This thing has it. You said it should have a second compartment. This thing has it. And you said it should have a second number of ferrous elements. It has one continuous ferrous element on its wall. So your claim is not patentable. Okay, so if you look at this and this, we can rewrite our claim to distinguish this from this. But someone who is expert in drafting claims can do this, can reword or rewrite our claim so that our claim describes this, but not this, distinguish our invention from prior art. So when the examiner says, okay, all your claims are rejected based on this prior art, should we say, okay, our patent is rejected and we cannot do anything about it? No. As I said, there is a correspondence between you or your agent and the patent office. You can easily change this claim, amend this claim so that you can distinguish it from this art, and you can send your response back to the examiner. The examiner reads your response and says, okay, it looks reasonable and I accept it, and you can get your patent granted. Let me say you something. In my 10 years of experience as a patent drafter, 80% of our patent applications came back with all their claims rejected. So the first office action we receive on our patents, for 80% of our patents, the examiner rejects all the claims. Are we disappointed? No. We know that we can amend our claims based on our specification and drawings and get our thing patented. And 90% of our applications have, ended up being patented. So this is what I mean when I say the patent office talks to you legally and not technically. And you need to use a patent agent to do that. Okay, let's see what happens during the examination. When you file your application and your application is sent to an examiner to do the examination, during the examination, your patent application is published, just like you have filed it, exactly like you filed it. So when you file a patent application with the patent office, after a while, that office will publish your patent application, and your patent application will be available to public. It is not examined yet, it is not turned into a patent yet, but the public can have access to it and can read it and be aware of the contents. Why is that? Why do patent offices, most patent offices, publish your application during the examination? Because they want third parties to be able to see your the content of your invention. One, to know that a patent application is being examined with this content, and two, they can present their observations on your patent application. Anyone can see your patent application during examination, and they are legally allowed to present evidence that shows that the patent office should not give you a patent. So anyone can file evidence with patent office that, okay, these guys have filed this patent application based on this thing that I found, their claims are not patentable. Anyone can do that. So your application is published during the examination. So many of those documents that look like a patent, and you can find them online, are actually patent applications. Some of them may have led to gone on to become a patent, but most of them are abandoned. So be careful about that. The documents that look like a patent, you should be careful. So most of them are just patent applications that have been published, and a portion of them have turned into granted patents. All right. So after the publication, the examination goes on until the back and forth correspondence between you and the examiner goes on until the examiner says, okay, based on your arguments and your amendments, I accept your claims to be patentable. And then they issue a patent to you. And after a while, that patent is also published and publicly disclosed. Because as I told you, in the patent system, we need to publish the patent. We need to disclose the patent to the public. The public should be able to read our patent application to know what our invention is and how it is made and how it is used. This was a part of the agreement. So this is the process that we need to take to get a patent on our invention in a country. All right. So if someone wants to get a patent in Iran, they should prepare a patent application, Iranian patent application in Farsi, the legal language of Iran, and file it in Iran and get it prosecuted and get a patent on their invention. If they want to get a patent in China, they have to prepare a Chinese patent application, which is prepared in Chinese, the legal language of China. And if they want to get a patent in Australia, they have to prepare an English application, the legal language of Australia. So if they want to get a patent application in these 4 countries, they have to apply for patents separately. Because as I told you, an Iranian patent is not valid in all these countries. So how an inventor decides where to get a patent on their invention based on their market analysis. We get a patent on our invention because we want to make money off of our invention. Where do we want to get a patent on our invention? The places that we have potential customers, the places that we have potential investors. So for example, this exemplary applicant believes that he can sell or make his invention in these 4 countries, and so he applies for patents in these 4 countries because he wants to benefit from exclusive rights only in these 4 countries, and in other countries anyone can copy their invention, and the patent applicant does not care, because if he cared he would have filed in more countries. But he says, okay, this is my playground. My playground is made of these 4 countries, and getting a patent on my invention in these 4 countries is enough for me. So let's go to the question that one of you asked. I said if someone filed a patent in one country, that patent is disclosed to the public, so the novelty is gone. So no one else can get a patent on the same invention in other countries because their claim would not have novelty. There are certain international treaties and agreements that facilitate getting patent protection worldwide in other countries. So there are agreements and conventions that help you get a patent on your invention in several countries without losing your novelty. One of these conventions is Paris Convention. I believe that my colleagues have discussed Paris Convention with you. And if they hadn't, you can look it up on the web. I'm not going to deep into these legal things. They're boring. So we have a Paris Convention. Most of the countries with a patent office are a member of this Paris Convention. Iran is a member, Pakistan is a member, India is a member. Every country in the world, we can say that most countries with a patent office are a part of this convention. It has 3 important provisions: national treatment, which says if someone from outside the country wants to apply for a patent application in your country, you should treat them as your citizens. You should not have separate queues for foreigners, or you cannot charge people from other countries more than your own people. You have to treat foreigners as your own people. And it has common rules that help the countries to lay out their patent laws more in harmony with each other, harmonizes the patent laws in different countries. And the most important thing, and the most important provision that I'm going to use to discuss things with you, is the right of priority. What is the right of priority? The right of priority says if an applicant files a patent application that I've here said first national application. So if someone files a patent application in one of the countries of the Paris Convention, that person has 1 year to file his invention in other members of Paris Convention and still benefit from the priority of this first national application. Imagine this first national application is filed on the 1st of January 2021. This applicant has up to 1st of January 2022 to file his invention in the US, South Korea, China, India, Australia, or any other country of their choice, and still benefit from that filing date of the 1st of January of 2021. So between the January of 2021 and the 1st of January of 2022, any application filed by this applicant will be treated as if it was filed in the January of 1st of January of 2021. So you can, maintain your right of priority, and this first application will not be used against all these subsequent applications. And anyone who files a patent application in these countries at any point of time after this first application, the right will be with you, and you can, get their patent invalidated. All right, so this right of priority of Paris Convention that allows us to maintain our right of priority for 12 months is very useful if we want to file our patent application in more than one country. Imagine I have invented a device. I want to get a patent in Pakistan first. I go to Pakistani Patent Office. I file my application, and from the filing date of that application, I have 12 months, which means 1 year, to decide in what other countries I want to file my patent in, and then start preparing patent applications and filing my patent applications one by one in these countries during this period of 1 year. This is the way you can use Paris Convention to file your application in several different countries during this 1 year period without losing your priority, without your first patent application be used against you regarding the novelty of your invention. This is the case for you. The applicant of the first application can, but no one else is allowed to file a patent application on an invention similar to yours. All right, I told you that if we want to get a patent, we need to apply for a patent in separate countries separately. But there are some regional patent systems that allow you to file one patent application with one language, with one office, and obtain a bundle of national patent applications that are valid in several countries. For example, one of these regional patent systems is ARIPO, the African Regional Intellectual Property Organization, which is an organization organizing the intellectual property matters of English-speaking African nations. ARIPO has 20 members, which I have designated by color blue on this beautiful map of Africa. The official language of ARIPO is English. So if you prepare an English patent application with the formal requirements of ARIPO and file it with the ARIPO office, you can prosecute that application and obtain a bundle of 20 patents that are valid in all these 20 countries. So in regional patent systems, you can get a patent that is valid in more than one country. And the validity of that patent is limited to the boundary of that regional system. Now we have another regional system, OAPI, which is a French abbreviation for African Intellectual Property Organization, that handles the intellectual property matters of French-speaking African nations, which I have designated by color orange in this map of Africa. OIP has 18 members, and you can file a single French application with one set of formalities with OAIP office and get a bundle of 18 patents that are valid in these 18 members. And we have EAPO, another regional patent system, Eurasian Patent Organization, which includes 8 members, Russia and some of the former Soviet Union's members. The official language of EAPO is Russian, so you can file a single Russian application with EAPO and get a bundle of 8 patents which are valid in these 8 members. But one of the most successful regional patent systems and one of the most prestigious regional patent systems is EPO, European Patent Office, that allows you to protect your invention in 42 members of the EPO by only filing one patent application in one of these official languages, English, French, or German. And the EPO will receive that patent application, that single patent application, and will examine it. And if it deems it patentable, will issue a bundle of 42 national patent application to you, if you choose so. During filing an EPO patent, an EP patent, you can choose what members you want protection in. You can choose 5 countries out of these 42 members. You can choose 10 countries out of these members based on the amount of money you're willing to pay to obtain these rights. So you don't have to obtain patent protection in all the 42 members. You can, choose to obtain patent protection in some of them. So when you file your application with EPO, if it is granted, you are given a bundle of national applications that are valid in all these countries. So what is the benefit of regional patent systems? You can file one single application and with one office and get a bunch of national patents. This is very important. This is very important. You don't get a single patent which is treated similarly in all these members. You get a bundle of national patents that may be treated differently in these countries, because at the end of the day, it is those states that determine how your patent can protect your invention, what the scope of protection of your patent is. And each of these countries can even extend the term of your patent or limit your term of the patent. Do whatever of these little tweaks to your patent application. So this is not a unitary patent application, which is Europe is trying to obtain. But these are a bundle of national patents that should be litigated separately in these countries. Okay. Someone has asked this: what if one gets patent in EPO and when examined in USA, patent is rejected on the basis of prior art? It is an interesting question. If you apply for a patent in EPO and use that 1-year period of Paris Convention to file a US patent application, your EPO application cannot be used against your US application. They will be examined separately. But it is highly probable that the examination of the EPO may be different from the examination of USPTO. You can obtain a patent. It is possible to obtain a patent in EPO, and at the same time, the US office reject your patent. Why is that? Because every country is independent in their examination. The EPO examiner says, okay, I think their claim has inventive step. But the US examiner can say, okay, I think it does not have inventive step. So you can file your patent application in 20 countries and get a patent on your application in 19 countries, but the 20th country can say, okay, based on my opinion, your invention is not patentable. It is possible. And you cannot force countries to accept other countries' results. You cannot, for example, you file your application with the US and then you file your application with Pakistani patent office. The US office gives you a patent on your invention, but the Pakistani office rejects your invention. You cannot yell at them and say, look, the US office gave me a patent and you're saying that my patent is not patentable. They can say, yes, because our examination is completely independent from their examination. In their opinion, your invention has inventive step, but based on what our examiner says, your invention does not have inventive step. And it is clearly stated in Paris Convention that countries are independent in their patent examination, and you cannot force a country to give you a patent because all other countries have given you a patent. They're independent and they can decide if they want to give you a patent or not. But their arguments should be logical and legal. So that's the case. I hope I made it clear that it is possible to get a patent in one country and in another country, your patent is rejected and you cannot yell at them. You cannot say anything to them. All right. And the process in a regional patent system is really similar to the process in a national office. For example, in EPO, when you file your application, after a while, you receive a search report on your patent application, which says what prior arts, what prior references are close to your application, and which of your claims are patentable and which of your claims are not patentable. And then if you decide to proceed with your application, it will be published. It will be publicly available because it's a part of the deal. When you file a patent application, you kind of agree that your patent can be disclosed publicly, so your patent application will be published. And if you formally request for the examination, an examiner will consider the search report and provide you with an official written opinion saying that, for example, this claim is not patentable, this claim is patentable. And of course, you have the chance to prepare a response to the examiner. You can discuss it with the examiner. Okay, you were wrong because of this, that, and you have to present legal arguments, fight for your patent to get a patent granted on your invention. After your patent is granted, there is a period of 9 months that anyone any person having access to your application can file an opposition to your application. Anyone can say that you have granted this patent to this guy. I have evidence that shows that his invention is not patentable. Here's my evidence. And if the evidence is correct, the patent office will, invalidate your granted patent. So after 9 months, no one can file opposition and you can enjoy your patent. So this is the process in most countries. Okay, I think I have 50 minutes. Okay, so the ultimate question is that I have invented something and I don't want anyone anywhere in the world to copy my invention. I want my invention to be mine. I don't want anyone to copy it. Can I get a patent that is valid in all the countries of the world? Can I? What is the answer to this question? Can I get a patent that is valid in all the countries of the world? And based on that international patent, I can protect my patent in every country. The sad answer to that question is that no, we do not have a worldwide patent system. And you kind of have to pick the countries that you want to protect your invention in. And because obtaining a patent is not a cheap process, you have to pay a lot of money to get a patent on your invention in different countries. You are kind of limited in the number of countries that you can obtain patent protection. So you have to choose them carefully. Yeah, I will come to that. This is actually a preamble to the WIPO system. So is there at least a way that makes it easier for me to obtain a patent in multiple countries? That's another question. So if I want to protect my patent or protect my invention in several countries, like I have designated here by these location marks, what should I do? And the first question is, how should I know where to file my patent application? I have to conduct a market search. I have to start negotiating with possible customers. I have to start negotiating with possible investors. And then based on my market analysis, I can decide in which countries of the world I need to obtain a patent for my invention. This is pretty much like a game of Monopoly. Have you played the game of Monopoly? I hope so. In the game of Monopoly, you buy streets and properties and try to protect your properties in these regions. It is exactly like that. You have to conquer only the countries that you have a market in and you want to commercialize, or you see a higher chance of commercialization for your patent. And you have to kind of give up all the other countries. In all the other countries, your invention can be copied and you cannot do anything about it. But in these countries that you have carefully chosen, you have exclusive rights and you can prevent others from making, selling, or using your invention. But is there a way to make it easier? Okay, one way to obtain a patent application, to obtain a patent in more than one country was the Paris route, which gave you 1 year to prepare and file different patent applications in different countries. But In 1 year, you have to answer this question, where to file? I told you, in order to understand where you need to file your patent application, you have to see in what countries or regions you have a higher chance of commercializing your invention. Getting a patent in these regions and countries is not cheap, so you have to decide carefully. Imagine a small company who needs to decide where to file their patent application in only 1 year. Is it enough to decide in which countries we need to file our patent application? Imagine you have invented something and you file a patent application for it, and you only have 1 year to decide in what other countries you want a patent application for. Is 1 year enough to do that? Of course not. Of course not. You probably need more time to find customers, to negotiate with them, to find investors, to negotiate with them. You need more time. So this Paris Convention thing has a drawback, and that drawback is time. The time is very limited. Just imagine you have to, in order to file your patent application in these countries, you have to prepare 1, 2, 3, 4, 5 different patent applications with 5 different set of formalities in 5 different languages. And you have to deal with 5 different patent agents or attorneys. Filing in 1 country is very difficult, let alone filing in 5 countries in only 1 year. So preparing multiple applications with multiple formality requirements in 1 year is impossible for a small company or for an individual. Just imagine if we want to file in 10 countries, it makes matters worse. And of course, in this period of 12 months, we have to pay all the fees. We have to pay translation fees and national fees. So we need to pay a lot of money. In this 1 year, we have to obtain the money and spend it, and it is really not feasible for people to do that in a limited period of 1 year. And we are doing all of this without having any feedback on the patentability of our invention. We are not sure that our invention is patentable because we haven't received the results of an examination. We don't know if our invention is new or not. So we are spending all this time and all this money, and we are putting all this effort into doing this in 1 year without knowing if our patent is patentable, our invention is patentable or not. So these are the problems that we have when we are using the normal way, the Paris Convention way. WIPO, the World Intellectual Property Organization, as my colleague has discussed with you, has come up with a solution to those problems, has come up with a solution to make it easier to file a patent application in more than 1 country. And that solution, my friends, is called Patent Cooperation Treaty, PCT, which, as the name indicates, is a treaty between countries. How many countries are in this treaty? 153 countries. 153 countries of the world are a party to this patent cooperation treaty. Iran is a member, Turkey is a member, most countries are a member to this PCT. What is this solution? The WIPO says, okay, I know the Paris route is not that efficient and it's sometimes very difficult to file several different patent applications using that Paris route in 1 year. So I'm going to present this solution to you. First thing first. In Paris route, you need to file several different applications with several sets of formalities. Here in PCT, you only need to file one PCT international application with 1 language and with 1 set of formalities. And this formality requirements is accepted by all 153 members. So you don't need to file several applications in several languages and several formality requirements. You only need to file 1 single application in 1 single language and with 1 set of formal requirements. And when you file this international PCT application, in addition of that 12 months of Paris Convention, I will give you 18 more months. So you have up to 30 months to decide where you want to file your application and discuss your invention with your potential investors, with your potential customers. You can do your market analysis and whatever you want. Another drawback of the patent system was the limited time. Here you go. I give you 18 more months so that you can do all those things. Instead of 1 year, you have 2.5 years to do all those things. All right. So basically put, PCT system allows you to file one single PCT international application in one language, in one formality, and file it with the WIPO via the PCT system. And when you file this PCT international application, it has the effect of 153 national patent applications. It's as if you have applied for a patent in all 153 members, the blue ones in the map, which is basically most of the world. So is PCT a patent that is valid in all these blue countries? Is PCT a patent that protects my invention in all these blue countries? Is it? The answer is no. The PCT is not a patent that is protecting my invention in these countries. The PCT is a patent application that maintains my right of priority in these 153 countries. The PCT system is here to make it easier to file patent applications in more than one country, not obtaining a patent, international patent application, which is valid in all these countries. So the PCT system is not a worldwide patent system. It's just a system that allows us to file an international application instead of filing several national applications. So, okay, let's get back to the PCT system and the services it offers us. One of the most important things that the PCT system offers us is that when we file a PCT application, they provide us with an international search report. It means in the PCT system, your patent applications is going to be examined just like a national office. So they will give you a feedback on the patentability of your system. Do you remember when I was talking about the drawbacks of the Paris Convention, I told you that we need to spend a lot of money in that 1 year period without knowing if our invention is patentable or not? Okay, there you go, problem solved. In the PCT system, if you file a PCT application, they will give you a feedback on the patentability of your invention, and then you know if your invention is worthy of being pursued. And then after 2 months, when they give you a feedback, your patent will be international, your PCT application will be internationally published. So anyone in the world can access your application. Do you see that this publication thing, this making the application available to the public is similar in all national, regional, and this international application filing system, because disclosing your invention is an inseparable part of filing a patent application. So your international application will be published at the end of the 18 months. And if you're satisfied with the search report and if you're satisfied with your negotiations during its 18 months, after the 30 months, you kind of have to enter the national phase of the PCT. What is the national phase of the PCT? Based on your PCT application, you have to apply for a patent in the countries that you have chosen. What are these countries? I told you, when someone wants to obtain patent protection in several countries, they need to have time to decide in which countries they want to file their patent application in. The PCT system gives you 18 extra months to do that. During these 18 extra months, you have done your negotiations, you have conducted your market search, and you have decided, okay, I need to file my invention in 5 countries. And at the end of the 30th month, you file 5 national patent applications based on your PCT application. And the only thing you need to do at the end of the 30th formal language of that country and pursue your patent application there. So you need to pay the fees, you need to, pursue your application separately in those countries. But so what does PCT do for you? The PCT gives you more time to elaborate your patent strategy. The PCT postpones payment of those fees. During these 30 months, you can obtain those, the money required to prosecute those applications, and so on. So does PCT act as a patent? No. Does PCT reduce our costs? No, it just provides us with feedback and gives us enough time to make a better decision when we want to file our patent in more than one country. So the Patent Cooperation Treaty allows us to file one application and pay one set of fees, one language, one set of formality requirements, and have the legal effect in all member states. And it gives us a time to develop our patenting strategy, and it gives us feedback on patentability. Who gives us the feedback on patentability in the PCT system? When you are filing your PCT application with a PCT system, you can choose the searching authority that conducts the novelty search on your invention. Based on your nationality or place of residence, a couple of options are presented to you, and between those options, you yourself can pick which patent office conducts the search for you. For example, all these patent offices that you see in this slide are international searching authorities. For example, for someone who lives in Iran, there are 4 options: Chinese Patent Office, Russian Patent Office, Indian Patent Office, and European Patent Office. You can choose who conducts the search for you. For example, if you choose India, Indian Patent Office will receive your PCT international application, and just like a national application, an examiner will examine your claims and decide if your claims are patentable or not, and then they provide you with the required feedback. You see, this is an exemplary page of an international search report prepared for a PCT application. Exactly like national offices, they provide you with feedback on your claims and the closest art, and they provide you with a written opinion in which it is said which of your claims have novelty, which of your claims have inventive step, and which of your claims have industrial applicability. So this is the feedback that you have. But does it mean that at the end of the 30 months, when you file patent applications based on your PCT application, those countries won't examine your patent and they will accept this international search report? No. This international search report is a feedback to you and is not legally binding for those countries. Those countries will conduct search again. They will again search your patent application. It is probable that your international search report says that all your claims are patentable, but when you file your PCT application, when you pursue your PCT application in a country, that country may say, okay, none of your claims are patentable. You cannot say, okay, I entered your national phase based on my PCT application and my PCT search report says my claims are patentable, so you should accept my claims. He says, no. We are independent in our examination, and we can reject all your claims despite the fact that your claims were accepted in the international phase of PCT. Okay, if you receive the search reports on your PCT application and you see that none of your claims are patentable, and you see that your invention is not that new, you have the chance to withdraw your PCT application before it is published. Why is it important to withdraw it before it is published? Because we don't want it to be publicly disclosed. We understand based on this international search that our claims are not patentable. We might want to work on it more to make it better, and we don't want people around the world to see that unpatentable version. So we have the chance to withdraw it, and nothing will be published and nothing will be disclosed to the public, and we can amend our application and file for another PCT if we want. So the PCT application is published. These documents that you see online that bear numbers like this, that start with WO, are PCT publications, and the application number of the PCT is PCT, and the receiving office that you filed your application with, and so on. So all these WO documents that you see on the internet are actually international publications of PCT applications, and these are not patents. You have to check if the applicant of these publications have applied for patents in countries or not. What happens if you don't apply for patents based on your PCT application? Your PCT application will expire at the end of the 30th month. So if you don't apply for national patents based on your PCT application at the end of the 30 months, it's as if you've never applied for any patent in anywhere in the world. So PCT system is not an international patent system. It's just a system that makes it easier for you to file your application in several different countries. It holds your spot in 153 countries, but at the end, you have to choose between those 153 countries, which countries you are willing to pursue your patent application in. And the filing process of a PCT is really easy. You prepare your PCT application. The PCT application is like a national application. It consists of a specification, drawings, and claims. Yeah, as always, I suggest using the help of a professional to prepare your PCT application. You can then file your PCT application. You have two options for filing your PCT application. The national or regional office near you is probably a receiving office for the PCT. For example, if you're living in Iraq or Pakistan, you can go to Pakistani patent office and apply for a PCT application, or you can directly file with WIPO. And they have an e-filing service. You can log in, get a username, password, and enter that portal, upload your documents, pay your fees by credit card, and obtain a PCT application. It is very easy and it can be easily done. So for filing a PCT application, you have to pay some fees: international filing fee, transmittal fee, and search fee. So PCT is not for free. You have to pay extra money to get all those options. And what are these fees that you need to pay? International filing fee, transmittal fee, and search fee. After you filed your PCT application, the PCT application is sent to the International Searching Authority that you picked. I told you that you can select who conducts the search on your application. Your PCT application will be sent to that ISA or International Searching Authority, and that International Searching Authority will examine your application and will provide you with an international search report and written opinion, which is considered as a feedback to you if your invention is patentable or not. So in these 18 months, you can receive feedback on the patentability, and you can conduct negotiations with potential investors and customers. You can conduct market search and decide in what countries you want to pursue your PCT application. Potentially, your PCT application holds your priority in 153 countries, but of course, no one has the money to obtain a patent in every single one of those 153 countries. Even large companies like Apple and Samsung file their applications or file their patents in 50 countries, 40 countries. No one can afford that many countries, to 150 countries, to support to protect their invention. So based on what you've learned during these 18 months, you pick, for example, national office A, national office B, regional office, national office. It is true, you can file for a regional patent office, based on your PCT application. For example, based on your PCT application, you can apply for an REPO patent, or you can apply for an EPO bundle of patents. So then you have to pay all those fees. And what PCT has done for you is that you have made your decision in a timely manner and with your eyes completely open, and it has postponed the fees of these national applications by 18 months, which is really helpful. So a PCT international application eventually leads to a couple of national or regional patents if you want. And if you don't do anything about it, it will expire. But if you choose some countries out of those 150 countries, you end up with 1, 2, 3, 4, 5, 6 patents, not a single patent which is valid in all blue countries. You only end up with patents based on your PCT application in these selected countries. And if you don't select any country, your PCT application will expire after the 30 months. So don't listen to those people who say that PCT is an international system that will protect your invention in all these countries. It is not true. PCT is just an application that eventually needs to be acted upon by yourself, and you have to enter it into the national phase of one of these 153 countries. And if you don't, your PCT application will be expired. And since it has been published, it will be used against you for later filing, and it will, eliminate the novelty of your invention. There are other optional choices during the PCT international process. For example, you can file for a demand. You can file for an extra examination step. When you receive the written opinion of the first search report, as I told you about national offices, when the examiner sends you the search results, you have the option to prepare arguments and a response to that action. It's the same in PCT. It's optional. You can amend or revise your application based on the first search result and then send your revised application to conduct another search. This is another option because you want to make sure that your invention is absolutely patentable and has high chances of being patented, because after these 30 months, you have to spend a lot of money to get patents on your invention. So you want to make sure absolutely that your invention is patentable. So if in the first search results, some of your claims were deemed not to be patentable, you can amend your application and ask for another examination, but you have to pay extra money. And we have other options. For example, you have to ask for supplementary search. For example, imagine I have chosen, okay, so the time is up. I was chattering, so I try to make it quicker. So other options are available to you. These are not important. Let's talk about the fees and wrap it up. The international filing fee for filing a PCT is around $1,453. Additional per page, you can file a PCT application of 30 pages for that $1,453. And you have to pay $16 per extra page. The transmittal fee is $109. The search fee depends on the ISA you chose, and e-filing reductions, if you use the e-filing service, if you file your application online, up to $328 will be reduced from all your fees. The search fee is different for searching authorities. For example, Chinese office charges you $328 to conduct the search. Indian office charges you only $34, while EPU charges you $2,000. So the cost of the search is different, and it is based on your choice. So let's just summarize what I have told you about the PCT system and the national and regional patent systems. A national patent application after examination leads to a national patent, which is valid in that country. A regional patent application after examination ends up to become a bundle of national patents which are valid in that region. A PCT international application after examination does not lead to an international patent valid in all countries. The examination of the PCT is just the feedback for you to make a better decision. And at the end of the international phase of a PCT application, it is you who choose where to pursue your international application. And you can pursue your international application in several chosen countries or regions. Let's look at the advantages one more time. The PCT postpones the major costs associated with internationalizing the application, provides a strong basis for patenting decisions. I told you it gives you time and feedback to decide in what countries you want to obtain a patent, harmonizes formal requirements. You only need to comply with one set of formal requirements, and protects the applicant from certain inadvertent errors. If you make some errors in the international phase, you can easily fix it in that one application, and that mistake does not propagate into all of your national applications. It provides the most efficient way for seeking multinational patent. So it is a perfect and efficient way if you want to maintain your options of obtaining several patents in several countries. And thank you. I talked a lot, and I hope I didn't talk too fast or too vague, and I hope you enjoyed this presentation. I wanted to make it as exciting as possible and make it as easy as possible, because I didn't want to be deep into boring stuff. So you can follow me on LinkedIn. I will be happy to answer your questions there. If you send me a message on LinkedIn, I will happily answer your questions, and I will be at your disposal. Okay, since the time is limited, I thought I rehearsed this presentation, and I presented it in 1 hour. And I thought, oh my God, my presentation is short, but it wasn't short, it was long, actually. All right. Okay, so I'm ready to read your questions in the chat box in the limited time that we have. If you have any questions, please feel free to type it up, or I don't know, if you raise your hand, I think the moderator can open your mic and you can ask your questions verbally. I don't know if that is possible or not, but I will be happy to. All right, I'm waiting to, thank you, wonderful presentation. All right. All right, you have me, right? Because my presentation just closed. Let me see the chat section, where did it go? All right. So no questions, all right. There are no questions. Thank you for your time. I hope you enjoyed it, and I've got nothing else to say. As I said, you can follow me on LinkedIn, and I will answer your questions there. And thanks to the moderators and organizers of this online seminar, it was an honor to be with you today. Okay, I'm at your disposal.
Thank you, Dr. Khallar Khani. It was most useful and helpful. I think the participants would agree with me. The fact that there is no question says it all, because it was very clear and straight to the point. Thank you so much for attending today, and I hope to see you again in other sessions.
Thank you, me too. Goodbye.
Okay, goodbye. For the participants, we will have now a 15 minutes break, I think, and we will start then. Goodbye. Okay, everybody, we will continue now. I would like to welcome Engineer Layla Zara. How are you, ma'am?
Hello.
Welcome to our session. I will give a few words of introduction about Ms. Zara. She is a graduate in intellectual property law from the University of Turin in Italy, and holds a master's degree in environmental technology engineering from the University of Wageningen in the Netherlands. I'm sorry if I said that wrongly. Patent specialist with more than 10 years of experience in providing technical and analytical assessments, patents and technology mapping, drafting patent applications, and designing the facilitating training in this field. Managing Director and co-founder of ICAF, Intellectual Property Services Company, consultant and lecturer of Iran Patent Center and Innovation and Prosperity Fund, and founder and member of the board of directors of Fazino Educational Institute. Welcome, Ms. Zari.
Salam alaikum, everybody. Thanks, Noor, for introducing me. Thanks for having me. Do you have my voice? No problem?
Yes, we have your video, your voice, and your presentation ready. You can start.
Okay, good. Salam everybody, I hope you are doing well and be healthy. I guess actually that you are a little bit tired because you've got during this past 3 days, you've got lots of information, and I guess you've been a little bit tired. I thought how I could present in a way that's less boring. I didn't find any solution, but I'm trying to have more attractive, more interactive presentation. I hope you like it and could be useful for you. What we discussed today is patent information, and we will talk about what are the patent information, why they are important, how to get patent information. This is the main topics we are focused on. For beginning, I draw your attention to the IP information, different type of IP that are patents, utility models, trademark designs that have defined clearly in the past webinars. So for this presentation, for this webinar, we focus on patent and how we could use patent information in our business, in our work, and in our research and development centers, and in our science and technology park. Patent information, they say that it's a valuable tool for supporting invention. But what do you think, how it could be valuable tools for supporting innovation, sorry. What is your thought about these tools that help innovations, and how we can use it for innovation, for innovative purpose? I think in Brian Khan, you've learned a lot about benefits and costs of patent systems and how they can make incentives for users to do innovations, innovative works, and something like that. But we focus here on patent information, how the patent information can use for innovative purpose. They say, you may have heard that 80% of technical information is published only in patent. You may have heard in many ways, you may have read it, but why, the question raised here, why the patent information or technical information are available in the patent documents, which are free available and no charge? Why do you think? Do you have any idea? I would like to say that if you have any question, if you have any suggestion or anything that you think worth to share, share it. I interrupt my speech and pay attention to your question if it relates to the question and could help the other audiences to make more understanding of the topics. So the question raised here is why 80% of technical information is patent documents? Why patent information is free of charge and available for everyone? Do you have any idea? The answer is back into the nature of patent. For example, imagine an inventor who implemented his or her ideas in an invention as invention, and he wants to benefit it. He wants to monetize it. He wants to benefit of many efforts that he made to benefit it and take money and something. But what is the problem here is when invention not protecting by law, everybody could use it, could copy it, and could free writing, and nobody could prevent those people who are copying the invention. So the valuable things, the valuable tools that support inventors is actually law of protecting laws of inventions that could protect the idea and in help of inventor, it could benefit the inventors. We should notice that we explain about protecting, but who provide this protecting? Governmental authorities or governmental office can provide this protecting tools for protecting implemented ideas that implemented by the inventors. But why government protect the information? Why protect such information, such invention? Why they should protect? It backs to the authority they have. Sorry, do you have my voice? Do you have my voice? No. Okay, good. Because my connection, I thought, was interrupted, so I asked that.
Do you have my voice?
Okay. So they go to the inventors, go to a government or governmental office as authority able to legal protection such ideas. But what does government authority ask from inventors? It makes a deal. It makes a deal between inventors and themselves, and ask inventors if they could provide disclosure, completely disclosure, properly disclosure of their invention. Then the government will give them a right, protecting right, that gives this protecting right as a patent, give exclusive right to the inventors, innovators, and they can have exclusivity around their inventions. So nobody could copy or could infringe the innovative works that they had made efforts, made lots of efforts to do that. So that deal is important because exclusive rights gives to the innovators because the innovators have to provide properly information about their inventions. Actually, they have to disclose completely their inventions to that legal authority in the governmental part, and for this disclosure they will earn exclusive right. Why, inventors, innovators, they are reluctant to disclose their information, but why government ask the inventors to do that, to disclose their information? What do you think? What is your idea? Inventors, you are working most of you, as I understood, you work in Science and Technology Park, and you have faced inventors that are reluctant to disclose their inventions because they say, if I disclose my invention, somebody could be able to copy it, and why I should do that? Yeah, to spread knowledge. That exactly, Kamran. Yeah, to spread knowledge. It's so important for governments, because as governments give this exclusive right to the innovators, instead, the governmental authority wants the innovators to provide properly information about the inventions. So they provide this provided information to society, and society can use it. Society can use it for preventing the application, and wasting budget and cost, and many purposes that we will be aware of them in next slides. When government give such governments give such exclusivity, and innovators provide their information to the public, to the society, society can use such information. Society can use such information, and for many purposes that we discuss them in next few slides. But this could result in incentive for society, because they see that somebody have their own exclusivity. They could monetize by using that exclusivity, and such monetization, such benefits they gain could make incentives for the other people in the public, and therefore this could more innovative works, because they as it works as an incentive, and they could do many works, more innovative works, and then when innovative works increases, then we have more economic development, and so on. So we discuss about why patent information is included, why the value of patent information, and why we can obtain patent information. But the main question that needs to be replied in during this presentation is, what is included in a patent document? What we've heard, we've read that 80% of technical information, but how we can get such patent information, how we can use such patent information in a way that could help us in innovative cycle, in service of society, society and economic development. This is a focus of this presentation that I present for you. Patent information normally includes three kinds of information: technical information, legal information, and business-related information. Do you have any idea about technical information? What is the technical information? Technical information is actually detail of invention. We in the next slides we pay attention to this part more clearly. But for now, I should just say that it's from description and drawings of the patent application, we can obtain technical information. We have also legal information. Functionality, features, functionality. Features and functionality are described in the patent documents, different features of an invention, technical information that is related to that invention, all are disclosed in the description, and drawings can help to this part. Legal information is from the patent claims, defining the scope of protection. It works in it limits the scope of protection. It says what the patent document we are reading are protecting, and what is the scope of the patent, and many things that relating to the frame of protection. Business-related information is interesting because many information, most of the people knows that there can gain technical information or legal information. Most people know patent at legal documents, so they can think that the legal information they can obtain from the patent document. But what about business-related information? What do you think about business-related information that you can get from the patent document? Do you have any idea what is the business information? Business information means that it works for what? Patent for business, why business needs to use patent documents. What is your idea? Business information can obtain mostly from the business one protect its profitability. Yeah, exactly, Kamran. Yeah, exactly. Profitability, but it's not limited to that. Business-related information give us opportunity to know who can be a licensor, who can licensor of our invention, who can we cooperate with them to to develop a product, who can be buy our invention. This this kind of information all are involved in included in the patent documents, and especially in the front page of bibliographic data of a patent, which is mostly in the front page of a patent. To find any collaboration opportunity, it could help us. As I understood, most of you are working in science and technology park. I want to give you an example. Imagine a situation that an inventor has filed a patent application and his or her application has been granted. However, for many reasons, he or she is not able to develop his invention by himself. He wants to know if there is a possibilities to cooperate, to find collaboration opportunity to develop it. Would any cooperation abroad interested in licensing or buying his invention? You as a consultant in a technology, science and technology park, need to do some search based on his or her invention to know who are active in this field, who can who you can communicate for these purposes. Communicating them to find any opportunity with this purpose is what you can do. Moreover, you may need patent information for freedom to operate. Freedom to operate is so important. I will discuss here freedom to operate. Do you have any idea about freedom to operate and the role of patents? For knowing freedom to operate, do you know freedom to operate? What's the meaning of freedom to operate? Imagine yourself developing a product by, for example, reverse engineering or your own creativity, okay? And you live, for example, in Pakistan, but you want to export your products to other countries, for example, to Dubai, to UAE, to Oman, to Turkey, or another countries, Iran. For exporting your products, you need to do a search based on the company name. For example, a company name. Why company name? Because you've heard an American company have filed a patent, many patents in, for example, in UAE or in Turkey, and the activity of that company covers what you are producing. So you need to search by the company name. What is the company name product? What is the activity of that company in that country, in that specific company? And you need to do a pre-fund search in claims also, which is called claim construction research, to know what has been covered by his claims. If the claims are covering your products entirely, if yes, you need to negotiate or even withdraw exporting to that country, because it limits your activity since it has exclusive right there. So you don't have any freedom to do something there. Or maybe you found by your research that you've done in claim construction that there is some difference between your products and the claims of their invention. Then you by this kind of searching, you will find You will find what is your freedom there, and how you can use such freedom. Maybe you have to license still some of previous innovations that they are protected by inventions, but by patents. But for the left, you don't need to license. Moreover, there is some other possibilities to no freedom to operate. For example, if a producer, if a company filed his patents in a country, but doesn't pay the maintenance fee, and so you have export your products there without any problem. Or maybe the patent they have expired, so you are free to export or develop your products there without any problem. And therefore, term and jurisdiction is too important. Terms means in fact the duration of protection. Duration of protection is 20 years for patents, and this information are available in the front page, because you can see when the owner of patent filed his patent, his invention, by looking at filing data, and 20 years after filing data, they have exclusive right, but otherwise you can use it without any limitation, because it would be in public domain. Another using of patent information, especially front page information, for business purpose is finding competitors. You may use patent information to know what your competitor do. You can monitor your competitor, their activities, and observe their path they are going. In here, in this slide, we've categorized some of informations that we can gain from patent and use in many ways. For example, is my invention new? If you want to know your invention is new or meets the patentability requirement, you have to do search and search in patent documents actually, and see if any inventions published already as prior art have covering your invention or not. What is the state of art? This is another purpose of patent and business. Which solution already exists? This is important because most of us don't have, for example, invention. But what we can use from patent information is finding problem solution. How we can do it? I will explain an example that may help you. One of our clients working on 3D printing and not working. This story is about back to 4 years ago, and he was started working on 3D printing. A piston that the 3D printing he works on. It was a piston for some ceramic powder, and then spread the ceramic powder with a roller, and then in the next step, a nozzle or printhead pours a specific glue on the layer, and then layer go down, and the next layer has to be formed with such steps. They were problem with such nozzles, how they could how the nozzles could spread the glue, and which points of the surface has to be covered with such glue. And we do a search. They needed to know how to produce this, and we do a search, finding many patterns, and many patterns, some other information they found also, and together from articles, some information we find from patents documents about how nozzles in other companies are produced, and also we found some other articles that we found them by the inventor's name, inventors that publish articles, inventors of specific patents also published articles, and some other information, various embodiment was observed in their website, also different website, their website and their collaborative partner, their partner website, and we gather all information and analyze them by themselves, by the by that technologies. By that technologies, you have my voice. Okay, it's green still because I see some disconnecting. And how they develop such 3D dimension production line and market their production, after getting many information, discussing with them, analyzing information we get from patent to find a solution for such problem. At the end, we develop, we know technologies develop the desired 3D printing and market the products to the other country. So patent information has many advantages to use, and who needs patent information? For example, scientists, researchers can use the patent information to monitor the newest technical development, to avoid duplication of R&D efforts, and they do a special search that calls technology transfer. A person or business who wants to file a patent for an invention, why they want to do patent search to clarify whether or not a patent application has already been filed for a similar invention. A business that wants to introduce a product into a new market needs patent information to clarify whether or not the new product is identifying an existing patent of a third party, and also a business that wants to know and wants to prove infringement of its product, to clarify whether or not the new product is infringing an existing patent of a third party. So this is some kind of use of patent information, and technology analysis is also is too important. Technology analysis, of patent information for technology analysis is very valuable because technology analysis don't use only by technologists. Policymakers can use technology analysis because they want to know what is the trend of a technology, how is going on a specific technology, and which jurisdiction developing the technology, what is the chance, what is the opportunity with new technology, and many information that they can gain from patent information, but not a patent document only. They need to gather lots of information from many patents and then evaluate them to obtain what they needed. Patent document in main, as we said, contains three or four parts. That legal information or business information and technical information included in these three parts. What are the patent? What are these main patent parts? One of them is bibliographic data, abstract or which is in front page, normally is in front page of a patent documents. Another part, another main part is claim. Claim is so important, and determining the legal scope of the invention, as we mentioned already, and we discussed with more details in the next slides. And also description, which is specific technical details of an invention and disclosing, disclosing what the invention contains. We can merge such information, such parts, not merge. We can identify which parts contains those information we mentioned already. For example, legal information, as we said, mostly are in the claims part, which is support and claims part, which makes a scope, which makes a boundary around the invention, and supporting other parts of claims is too important, because claims makes boundary, but other parts also support claims that to make ensure that claims are working well. Another part, as we said already, is description that contains technical information. Description, some people says that drawing is included in the description part, but some other people, some other scholars believe that drawing is another part. We discuss about business information, which normally, not most of them, can be found in front page, but other parts can be helped to understand and obtain such patent documents. Okay, so we want to explain front page information in more details in this slide. Front page contains numbers, data, names, codes, text, drawings. All information is in front page, which is called another name of front page can be bibliographic data. What is the numbers? Numbers including application number, publication number, grant. The number that assigned to a patent application when it filed, for example, when a patent application is filed in a patent office, application number is assigned to that document. Publication number assigned when that document is published, and grant number is what given the number given to a patent documents after it meets all requirements, all patentability requirements. So there are numbers. In the next slide we discuss about these numbers and the information we can get only by seeing these numbers. There are also data filing data. We have filing data, application data, priority data, grant data, publication data. They are so important because you know, filing data is the data we file or we register our patent application. And this data, this filing data can use, we can use this filing data when we want to, for example, register our patent in abroad, and we claim priority by our filing data. Then the filing data we had in previous country would be considered as a priority data. So, for example, you file your invention for example, in Nigeria, and then you go abroad and you want to protect your invention in another country, for example, in Europe, and then you have another filing data in Europe, but you use that data, that application number, that application that you already filed in Nigeria as a priority data, a priority number of your invention, of your next invention that you filed in Europe. Therefore, they are so important, and important because we determine the expiration by knowing the filing data. As you know, 20 years after filing data, a patent is expired. So filing data and priority data all are important to determine the terms, such terms. We have also grant data, publication data, which after granting a patent, after granting after meeting requirements, patentability requirements, a patent could gain grant data. We have also drawings. In the first page, we have only the main image that inventors thought it could convey all embodiments of this of his inventions. We have names including inventors' names, assignee names, applicant names. You know, who is real owner of the invention, called in different ways. For example, applicant, assignee, proprietor, owner. In different patent application, we could see such names, such specifications. That we also can see examiner attorney names. We see also codes, classification codes, international class, US class, for example. We can see also text, title, and abstract, and notice. So we want, in the front page, we have such information, but what we could gain from looking at the first page, we said that we can see many information that could be useful for our business activities, for our developing our business or something. So why and how we can use them, and how we can understand what, for example, we can understand from numbers we see for looking at just on the front page. We can what are you seeing in this slides is the information example obtained by front page. Whether this patent document have legal protection, you can find answer of this question just by looking at the first page, front page. Whether this patent document had met already all patentability requirements, for example, novelty, industrial applicability, application, having an invention step, you can know this you can see if the patent you've look at the first page have met such requirement, patentability requirement that could be useful for you. You also you can find is the present patent related to the invention of tools, equipment, composition, methods, or related to the registration of industrial design or registration of plant species. You can also can find that the purpose of registering this type of patent solely to prevent others from patenting your technology or in another purpose. And you can also find that whether the search results available in the patent documents or not. Many patents documents, especially those are published in Europe and published through PCT, have search result, and you can find the search result in the patent documents you already have. And by looking at only the first page, you can find if there is such information available in that patent documents or not. Now we show you some examples. You see such numbers, such numbers in the front page, and you want to know if the patent document you have in your hand, and you look at this number as a publication number, has already patentability requirement or not. What do you think? What is your idea about this number? WO 2080 A1. What do you think? Do you think it's protecting? It has protected. It met patentability requirement already. It has been granted, issued, or not? What do you think? Okay, and how did you, Omar? How did you get it? Last lecture was about it. Okay. Okay, so yeah, this is a patent that was published in through WIPO PCT manner, and it has WO shows that it was published by WO, and it was filed through PCT systems. And A1 it shows that it's only application. So you can find by looking at the first and the last words of a patent to know what is the situation of a patent. The next one, what is your idea about the next one? EP. I was not in last lecture, so I was not aware of that. European patents, yeah. European patents, exactly. European patents, and what is A4? What is the meaning A4? You find this application and it says that it's A4. Do you have any idea? The next one was published where? US, because we look at the first two words, and we can, that is country code, and also we look at the last word, and we can understand the situation of the patent. This is application or grant one. This, the third one. Any idea? This shows that it was published in US, and A1 means that is first, you know, first edition of application. A1 means application, but if the patent document, a patent application, made all requirements relating to patentability requirements, it would have it would granted, and then you can find B in the at the end of the number, publication number, which proves that this document has been granted, met all requirements, patentability requirements, and so has been granted already. This one was published in Japan and then granted. This one also published in China and has been granted there. Therefore, from the looking at by looking at the numbers, you can find many information about the patent documents. We also have priority data, filing data. We define them already. But have you heard, have you heard about a patent family? Okay, patent family, the other participants? Patent family, we have heard patent, that if we search in Google, if we search in Lens, there are free patent databases that normally used for finding patents. If we search in those databases, we see the item of patent family. But it's worth to know what is the patent family. When we talk about family, we can say that they share the share point of the family is a bloodline. But what is the what is the characteristic of patent families is actually priority data. They have the same priority data, and that is the difference between patent families and other other patent documents. Patent families, for example, you file your application in one country, for example in Pakistan, and after before 12 months you decided to file your patent in US or Europe or another countries, and claim your priority you had in Pakistan, and then you file your patent in US. After a while, you decided to do some kind of development in your patent and in your invention, and you file another patent, but you prefer to do such patent, you prefer to file such patent in Europe, Therefore, you have, you make patent family, which priority data is the filing data you had already in Pakistan, but other documents are relating to such priority data, and you will have you will have a patent family. You may expand this by filing a patent in another countries, or by developing those inventions. Therefore, patent family is a group of patent that relates to technological feature, technical feature of an invention, which all have one priority data. Therefore, the importance of priority data could be explained in having patent family. A patent family, why we use patent family, why it is important to know patent family, because most of the patents grouped in a patent family disclose same invention. For example, the patent family you filed in Pakistan, what you disclose, what you claim is more or less similar to what you have disclosed in your patent in US. Therefore, it is not necessary, if I want to get more information from your patent, from your innovation, it doesn't necessary for me to review all patents, review all your patents and search all patents you have filed in patent in Pakistan or in US or Europe or somewhere else. Only one of them enough for me. So in many patent database they are they have options to choose patent family, and it prevents duplication, the duplication of seeing patent in the list. So you can only find what you want, one of the group of family, and then reviewing it. If you get enough information from that patent, it's as done, and then you don't need to do search in other patent. What do you think about this number? We've said that patent documents, patent number can disclose what is included in that patent document. What do you think about? What is your idea about this one and this one also? What kind of patent this one is? This one? Omar Sharif, am I right? Do you have any idea? Okay. Okay, what do you think about these other participants? Yeah, design, exactly, design patent. Because by looking at the number, we can find that it is different than the previous numbers we saw already in the previous slides. So this number has D and S at the end. This shows that this patent is design patent. And this one, what is your idea about this one? This one, PP 15. I mean this one. This one is a plant patent. You may have heard in previous sessions that US have three kind of patent: plant patent, design patent, utility patent. They also protect plant innovations as a patent, you can find such information, such patents in their database. This one, there are few actually of these patents, but there are some of them. And you can find them in the USPTO database. Names. This is you've already know about the names. We have inventors, we have applicant. As I said already, can call as applicant, as proprietor in Europe, assignee, owner. Applicant and inventor are different because inventor has moral right forever, but applicant has such exclusive right for monetizing, for benefiting from the patent during the period of protection, during the term of protection. Therefore, applicant and inventor are different in their, property they have, but sometimes inventors are applicant because individual inventor, for example, have done some inventions, some special work, some innovative works, and nobody else, no company else help him to develop his products, his innovative products. So it is the the difference between applicant and inventors. We can, as I told you in that example, 3D printing example, we use this name to find other activities of the inventors. They may, for finding solution problem, finding a solution for a specific problem. We find, for example, a patent, but the information discloses in that information, in that patent may not be enough for us. Therefore, we need other supporting information, maybe a patent family, other patents that paid attention to development of such invention could help us. But sometimes searching inventor's name in the patent database or in Googling the inventor name could help us to find some articles, some activity that the inventor already done. And by tracking such activity, we could gain more information, and gathering all information could help us to analyze better the technology. We also have examiner attorney, but in most of the patent documents in the developing country, we don't see the name of examiner attorney, but examiner and attorney mostly are are part of the patent front page of the US patent, and sometimes in European patents we will find attorney name or examiner name also. What else we have in the first page, in the front page? We also have patent classification. Do you have any idea about patent classification code? Have you heard? How many of you already used such codes for finding inventions, for searching, or for finding solution problems? How many of you I would like to know? If you have already worked, please type yes. Nobody? Okay. Okay. Patent classification, in fact, is a code. Patent classification, as you see, we see international classification, and they are codes. But why? What is such a structure of these codes, and what is the meaning of these codes? If we look at the pre-fund of this, they are, we can see the similarity between them. But what does that mean? What we can find, what we can use from this code regarding to the purpose we have for searching the patents. When you file a patent in a patent office, they want to archive it. They want to keep it, but they keep it. It's better to be done in a specific technical feature covered the invention. So most patent office give a code for a specific technical feature and categorize inventions that they file in such categories. In such codes. However, countries want to search novelty. We want to search if one invention has inventive steps, and we want to deeply go into the patent documents and see if it find all information relating to a technical feature. But knowing each country codes is not possible. Therefore, WIPO provided an international agreed classification codes, and most people in most documents, most examiners use such classification code in the patent documents. Now we have this kind of one, but what is the structure of such code, such agreed code? Hierarchical structure of the IPC, it calls the agreed international patent classification, or IPC, has this hierarchical structure. This has 8 sections, 129 subclasses, more than 6 classes, more than 20,000 groups. But what are these classes divided? All our technology we have in 8 sections. Section 1 position, section is categorized for you to search if it has novelty or not. But section B, as we see in this picture, has its own more than 100 classes. It's too much classification, IPC classification in the, if you go to it, you can find classes, subclasses, groups, subgroups by clicking only on the on such sections. This, the code of classification codes contain theme titles. We went to A47. It's about furniture. It's human necessities, a general categorization. A37 is furniture, domestic articles. A37H contains subclasses and explain the classes in more details. What we have, what technical features we have in classes have more branches in subclasses. A47H only related to furnishing for windows or doors, covering windows. And A4781, it relates to curtains, suspension device. When you want to find ideas about how people use or how people use device for suspending curtain, you can only search A47H. This is only one example for many technical features, for many technical, technical view we have around us, around ourselves. We can find specific codes. As I said, it contains symbols and titles. I click, after clicking on each section, you will find such, subclasses, classes, groups, subgroups, and you can read whatever have been written in front of them and define such code. Therefore, finding international code is not difficult at all. Now we back again to this number. We look at a front page of the patent documents. It's Chinese. It's difficult to know. We don't understand the title. We don't understand the abstract. We can just see that it has JP. It's clear that it was published in Japan. And what we want to know, what technical feature has been disclosed in this invention. Invention is related to which technical features. Then we go to this part, and international patent classification has a specific possibilities. You can only just file your codes here and search it, and after a while you will have many results. For example, for this I did search C12N, and it was about, I brought results here, and it was about mutagen or genetic engineering. So the patent we saw, we didn't understand the the title. We didn't understand the the meaning of abstract. It was written in different language. Only by knowing the IPC and by examining the IPC, by searching such IPC in the website International Patent Classification, which was developed by WIPO, you can find exactly what the patent is about. In the front page also you have abstracts. Abstract is what? It's general information about the information. Normally is the first claim written in less legal language. It differs, there are many differences between abstract of a patent and abstract of an article. In abstract of an article, you will find maybe a result of that, of that article, many useful, but in the patent, it's not abstract. Is useful, but not as useful as article, as not useful as abstract in the articles you see in the journals, because it summarizes or explain the first claims. It's a legal language for protecting for protecting a device or whatever has disclosed. It's it summarized the first claim here, and maybe you can understand exactly what is that cover. Mainly the first claim are the first claims are are put here by different in language, making difference in languages. It has limitation in words, so it must be as short as possible. We should notice to that. This is, this patent abstract I've brought here is nanographen patent, which was developed many years ago. But as you see here from the abstract, it still has written in legal language, and it's not easy to find what does it cover. You may see some other documents in patent, some other parts in a patent document, in other patent document front page. For example, you may see notice, and you may see some explanation about extension of terms and so on. Therefore, you can find, for example, in this example, you can see that provisional application number was filed, and data, it gives the data and the number of application that this patent referred to. So it has, it has patent family because all are related to each other, and finding only one of them could help you. What is the patent document reveals about the technology. In other part of the main part actually is in patent document is the claim section. What is the claim section? Patent claims express the scope of legal protection of invention. In a claim, we explain the elements, the relation between elements of, for example, a device, for example, elements and process, different process, process of a method, and many things such that. Therefore, claims has to protect the invention properly, and makes a framework around the invention. Searching for patentability is another work, is another job that we search patents, why we use claims when we want to see if our patents or invention is patentable or not. We have to see, we have to examine if the patent, if our invention, if the invention we provided met patentability requirements such as novelty, such as inventive step, and etc. Therefore, we need to do a search, and when we want to do such search, it's better to search in claims, and it could help us a lot. Searching for patent infringement, for example, you in an example I explained already, when you develop a product and you export it in another country, some people may claim that you infringe their patents. To evaluate their claims, to know if they are right or not, claims has to determine the scope of the claim has to be determined. Research has to be done for knowing the construction, the coverage of the patent scope, and all are so important. These are some kind of application of claims, when we are going to search in patent documents. This slide shows the patent and the framework if all elements of a product included in a patent claims, then infringing has been, then there is a claim of infringing has been true. If there is no, if your product is outside of the such framework, there is no infringement, embodiment, and no threats. Claim structure, we see it is important to know that mostly claims are contains three main parts: preamble, transitional phase, and body. What is the preamble? Preamble explain general view of a invention. For example, they say an apparatus, a device, an article, a composition. Mostly they started by these words. A method, a process. In transitional phase is something that relates preambles to the body of the claim. And some words uses for this purpose, for example, including, containing, characterized by, comprising, consisting, and body explain the elements, technical features, and it also explain the relation between technical features that covers by claim. In here, example, a device comprising a pencil and the light attached to the pencil. It has two elements, a pencil and a light, but it doesn't say only a device comprising a pencil and light. It has said the way that they are connecting to each other, a light attached to the pencil. We have dependent claims, independent claims. What is the difference between them? Independent claims contains the main technical features, and main technical feature of the invention are explained in the independent claims. demands the most protection and legal protection, and indicates the main components, techniques, and step of works. Dependent claims refer to that independent claims, has a more limited scope than the independent invention. In any dependent claim, characteristics mentioned in the independent claims is generally defined. Now we go to description. If you have any question, please type it. Am I connected? Do you have my voice? Okay, good. I saw this message that connection problem. Okay. Another important part of a patent document is description part. What is description? Description actually defined the invention clearly, but how it defines the inventions, you know, it is important. Whatever we know about the invention cannot be included in a description part. You know, we should be careful about this part and drafting description as we were careful also about drafting claims. Description should include all elements, all all details about what we explain in the claims part. So a person in ordinary, how they should be, you know, in what language, in the very plain language, but not so plain language, you know. Therefore, finding information from the description is still difficult, because it, description comes to support claims, and claims is written in legal language. Description supports such claims, you know, explain all details, but not far from the scope of the invention that was claimed in the claim sections. And how it could be written? It should be, you know, written in a detail, in a way that a person of ordinary skill in the art could be able to make it. You know, it should be disclosed properly, that a person skilled in the art of Fosita could make it by brought information in the description part, could make it easily. Some important points about description are it is impossible to change after filing. We should notice about that, because after a while, after we file a patent, as you said, as you heard already in the previous sessions, it is possible to change claims. But when you change claims, when you change a scope of the claims, when you limit the scope, it is not possible to do some change in the description. Therefore, you should be careful about it. It also mentioned as a dictionary of to interpret claims. You know, if we want to understand claims, it is better to understand what has been written in the description part. By referring to description part, we can interpret claim. It is used as a basis for reform in the claim sections, and two main functions of the description is supporting claims and enabling. Enabling is so important because it needs, it is a condition, has said, to write a patent description in a way that a person who are familiar with that art can rebuild it. So it is true that it's must supporting claims, but we also attend to this fact that it is not just limit ourselves to such claims, to such language. We also generate we also need to be more generous about giving information. It mostly contains 4 parts: technical fields, background, detailed description, summary of the invention, and for example, in the technical field, general statement of the invention are defined. In the background, discuss about what was already in art, and what is the difference between this current invention and the previous inventions, previous works, previous arts. Detailed description explain exactly what is the as we said already, what is the relation between claims, relation between elements that was claimed in the claim sections, and summary of the invention is the claims, but in a plain language, in more plain language. And if we want to understand, if we want to read a patent and we can't understand anything from claims because it has its own legal language and maybe difficult for understanding, it's better to refer to the summary of the invention. Summary of the invention explain such claims, but in a more plain language. Another part of the patent documents is drawings. Drawings is so important. Drawings is to better understanding the invention, and mostly it supports description. It is so important because sometimes by writing description we can't understand. By reading the description, we can't imagine what was the invention exactly is. But by using drawings and finding relation between drawings and description, we can find exactly what is the description about. Enabling, it must clearly show all aspects of the invention that has been claimed. And also it can be in the different formats, for example, in diagram, shapes, photos. It should be black and white, so we have to be careful about that. It has its own standards. For example, this one, this one is a drawing the inventor gave us, but it is not acceptable by many patent office, because if it converted to black and white version, it is not clear. Therefore, inventor had to provide another image that contains enough information. Okay, we reviewed the patent documents. In here, we know patent information search. We know more about patent information search, databases, how we can search, and how we can use the patent information. Patent searching is process steps is defining the purpose. defining the purpose is so important to choosing a strategy, choosing a useful strategy. After having a purpose, we can choose a strategy and select the database and collect the information and remove inappropriate information. What are the goals for searching patterns? It is different. For example, it should be, it can be identifying and set goals for the production of newer products and technology. It can be monitoring competitors' activity or tracking competitor activity. It can be find solution to existing technical problem. It can be, the aims of searching pattern can be finding research feed for innovation center and research and development center. It should be getting up-to-date information. It can be avoiding duplication, vesting capital budget. It can be finding possibility-based commercialization and evaluate a particular technology also. But do you know what is the searching strategy? I don't have your voice. Okay. Okay, do you have any idea about what is the patent strategy? Why patent strategy is so important? Patent strategy, patent searching strategy shows us what to search, words. For example, what to search for. We want to search words. By using words, we want to search by using classification codes. I defined already. If we want to use words, we have to so careful about using synonyms also. When we want to use IPC, International Patent Classification, we must be careful about using groups, subgroups, subclasses. Maybe we use subclasses and we miss some useful information that could help us. Maybe we use one word that we think related to that technology, but we forget using synonyms and we miss some other information that have been disclosed in other documents, using not the words we use for search, but synonyms of that words. Where to search is so important. Where to search, it depends in our aims. For example, if we want to gain idea, it is not wise to search in claims sections. We want to gain idea much as possible. So it's better to not limit ourselves to, for example, to claims or descriptive claims or title or abstract. It's better to to wide our search and search, for example, in full text. But when we want to infringing search, to do infringing search, it's better to to limit our search based on the claims. Therefore, it is important to know where to search. And more important is to know the aims of our search, to specify which part of the patent we would like to search. Which database we do our search in there is also important. Sometimes for some purpose we need to do expanded search and want to more analyzing. So using free database is not useful in that situation. But for most purpose, using free database, patent database, I mean, is wise and useful and could help us very much. It is that this page, shows the importance of synonym. For example, if we use clips, if we use clips and we don't use such words, synonym words, it's we miss some patterns that contains, for example, catch instead of clips. This patent, for example, is not using clips but has used catch. So it is important to use all synonyms together. We must also be careful about homograph. For example, for clips, this is a clip, but clip, when we use clip in the searching patent box, we can have many inventions. We can have many results that have used clip in their definitions, and there are contain clip word, but they are different, cover different inventions. For example, we want such clips, but we don't want such clip. How we can it's how we can find and limit our search. Do you have my voice? It says my internet connection has problem. Do you have my voice? Okay, good. So if you have, for example, if you type clip in a searching box, you have many different type of clip, but you only want this kind of clip. How you can limit your search to find patent information that contains information about such clip? By using classification code. Therefore, sometimes we need to use words as well as classification code to get better results. Here I used classification codes. For example, I recommended you to use classification codes because it has many possibilities. For example, you don't want to use all, you don't want to click all sections and going to a class, subclass, and so on. You just want to know what is the classification code relating to one specific technology. In a search box, you can type what you want, and it brings a list of classification codes. By clicking on them, you can open them and then see which of them is relating to your work. Therefore, for getting better information from the patent search, it's better to use, in some case, classification code. Searching technique is related to using truncations, Boolean operators, adjacent, nesting, question mark. They seems you may think they are easily used, and it's not important. But many bad results we had already by using. Not properly using of such operator. For example, when we needed to use or, we didn't type anything, and therefore we had a list of results that didn't work for us because it was not what we searching for. Therefore, it is too important to use truncations, Boolean operators, even parentheses or quotation marks in a suitable ways. For example, why we use, it is a kind of using truncations. You want to find all inventions relating to electronics. You know, electronics can come electronic, electromagnetic, electricity, but if you, for example, type electronic, you can't find, you can, you know, your result list doesn't contain electromagnetic patterns. Therefore, you need to use asterisks. You know, you use the elect and then use asterisks, and then it brings you all the informations, all the patterns that I've used, elect, and it is similar between all of that words. And or also our other Boolean operators are main operators. For example, when you use clip and hooks, it finds patterns that use clips and hooks. When you use clips or hooks, or is Boolean operator, it finds patterns that have clips or hooks. Therefore, you have lots of patterns. So be careful about what you are searching. Not is another possibility that, you know, another operator that could help us to have wiser search, because sometimes we want to use, you know, want to exclude some specific words from our searching. Therefore, not operator could useful for us. In some cases, you need to approximate your operator. For example, when you use corn and fertilizer, corn, you know, it brings for you lots of search result. In page 2, you have fertilizer. In page 61, you have, for example, or page 14, you have corn. Therefore, you have to limit such results. For this purpose, using near before can help us, because it makes, you know, searching more carefully, and we can get more related results to what we want. In the next few slides, I introduce some free searching database. Google is one of the most important one. If you search googlepatents.com, it brings this you know, page, but it has advanced search, and by searching advanced based on specific information, you can find specific information and combination, and even combine such you know, such searching to get better result. Free Patents Online is another free database that use, but it is not you know, updated from many years ago, and it is not contain all documents or patent documents such as the Google. In another database, free database that you can use for your searching purposes, PatentScope, developed by WIPO. PatentScope, it has many kind of search, advanced search, field combination search, cross-lingual expansion, and chemical search even. It has a possibility to use, you know, search chemical components, and it has ability to search them very properly. This is the, you know, the feature you can see in the PatentScope. SpaceNet is another free patent database developed by EPO, and it has many advantages. you know, it has many features that brings you many advantage. It has advanced search, it has filtering results. In advanced search, you can combine search fields, names, words, data, specific fields. In the filtering result, by filtering result, you know, by clicking and filtering result, you can filter result based on the country. For example, which country have the main patents in that field. By you know, you can use filter it by data, by applicant or assignee, by inventor, and it brings you many advantages. But which one of them you would like to use, it depends on you, because it you know, they are free. They have some deficiencies, but some many advantages besides. But it depends on you which one of them is easier to use. So thank you very much for your attention. I know you have been so tired, and I'm here for your questions. Okay, dear Noor. Excuse me for.
Thank you, Mrs. Zari, for your interesting session. I hope the participants have enjoyed it as much as we did.
How long does the patent registration process take, and what happened if the application wants to add an additional claim that has already been granted? It is a good question. How long does the patent registration process take? It depends on the jurisdiction. It depends on the patent office you use that office for registering your patents. For example, if you register your patent in Iran, it takes 1 year, 1.5 years. But if you you know, file your patents in Europe, it may take 4 years. In USA, similar. You know, it depends to the patent office you have registered your patent. And if the application wants to add an additional claims that has already been granted, it is difficult to add claim to that, you know, what you know, granted already, because it has limited time, and there is a limited time to do some amendments on it. Therefore, it's better to know what is the rule of the country, which country you are from. It depends. Okay, Indonesia. Okay, for example, if you want to add claims in your US patent, it depends on your you know, when did you your patent granted. For example, if granted 2 or 3 years ago, it is not possible to add some claims to that. But you have some possibility to add claims before granting. Normally before granting. If after granting it's your purpose, it's better to do divisional application, to file divisional application and continuation in part application, or something that such patent office let you. Therefore, it is wise to know what jurisdiction, what is the rule of that patent office you're you know, you're implementing, you're doing, you're filing your patent. There let you. Normally, it is not possible to add claims in the granted patent. It is wise to, for example, divisional patent, for file divisional patent, if rules of your country let you. Do you have my voice? Valid. Do you have my voice? Okay, welcome. Okay. Okay, other question? I'm here for your questions. If there is not any question, I will stop here. I'll stop here and then okay, there is not any questions. So thank you very much for your attention. Thank you very much for being with me. And I hope to see you somewhere. And if you have any questions, my information is in, is available, and you can contact me. Thank you very much.
Thank you so much, Mrs. Zari. I hope everybody enjoyed the session as much as we did. I hope that you can hear my voice now, because you clearly had some technical difficulty. Okay, everybody, thank you so much for attending. Now we will have some final words from INSTP, the Inter-Islamic Network on Science and Technology Parks, Secretary General, Dr. Ali Basti. Thank you.
Thank you, Chairwoman. Hello, everybody, and thank you for participating in the 3-day training course. My name is Ali Basti. I am president of Gilan Science and Technology Park in Iran, and also Secretary General of Inter-Islamic Network on Science and Technology Parks, or INSTP. It was our pleasure having this many participants from all over the OIC states. I hope you found the content of the sessions beneficial and that it will be of use for you in your work. I would like to take this opportunity to acknowledge and express my sincere thanks to His Excellency Dr. Muhammad Iqbal Choudary, COMSTECH Coordinator General, for his diligent support of INSTP programs, as well as COMSTECH consultants on Inter-Islamic Networks, Dr. Muhammad Ali Mahesar, for his guidance, and all the staff at COMSTECH who helped facilitate the sessions. I would also like to thank the honorable speakers for the valuable topics and discussions they provided. And finally, for what follows, the test or examination will be announced to registered participants, and my colleagues will share all the details with you in the following days. Successful candidates will be invited to participate in the workshop here in Iran that will presumably take place no sooner than 2022. And best luck to you all, my dears, and I hope I see you here in Iran, inshallah. Goodbye.
Okay. Thank you so much. I hope it was beneficial for you, and we apologize for any technical difficulties that we might have had. like losing some connection and some mistiming. I apologize for that. Regarding the test will be held on Saturday, as we have mentioned before. It will be on Saturday, November 6th at 10 a.m. GMT. So please be careful regarding your time zone. It's at 10 a.m. GMT. The test will be for 1 hour, and we will send you the link for the test. It will be held online. It will be a multiple choice test. So best of luck, study hard, and we will welcome the winners in Iran. Thank you so much and have a nice day.